Mr. Graver, I just want to clarify. It seemed to me that what you were telling Justice Kavanaugh might have been different than what you said to Justice Gorsuch, and I want to make sure that I didn't misunderstand that. When Justice Gorsuch read you his proposed rule statement, it didn't include anything about necessarily having to consider the evidence of adaptive functioning, but I understood you to tell Justice Kavanaugh that you would have to go on to consider such evidence, and that in some circumstances it could outweigh the IQ scores, even if they were in, say, the 73 to 78 range. Is there a difference, or am I misunderstanding?
I think a little bit. The part that I would want to focus on is the adaptive functioning piece, is that there's some aspect, I think, as we were getting at, there's some rule of Hall, taking Hall at face value, that at some point IQ scores alone can't be the only thing you're looking at. I do think states have some discretion after that to structure what the other evidence is. And I would imagine that a rule that, for instance, focuses just on conventional evidence of intellectual functioning would be constitutional. The way in which that, if a state imposed that substantive standard, the question that would follow is, well, are Hall's references to adaptive functioning, that dicta itself, is that something this court wants to give the force of law, that you need to consider this bucket of evidence in particular? I don't see any constitutional mandate to do that. But I think the only point is that so long as your scores touch a certain level, perhaps IQ can't be the only thing you're considering at prong one.